big story of the morning. The Free State High Court will today hear if convicted rapist and murderer Tabo Bester has managed to get legal representation to finally set a date for his escape case. The court has also had to hear whether the lawyers for another accused, that's Tabo Bester, has been paid. 9 accused, including Dr. Nandipha Magudumana and her father, face charges of aiding Bester to escape from prison in Mangaung back in 2022.
At the last court appearance, Bester's lawyer, Advocate Mohammed Sidat, withdrew from the case, leaving him without legal representation. Bester then addressed the court, telling the judge that his rights were being infringed as he was denied private consultation with his lawyers. He stressed that further delays would follow because failure to consult always led to his lawyers quitting. He also said no lawyer wanted to represent him because the state had painted him as untouchable. Bester also lamented that he was not allowed to dress in his own clothing. Bester was ordered to get a lawyer who would submit an application to the court to address his grievances. A legal analyst has weighed in.
Once all those aspects has been covered, then we'll expect the court to set the trial dates. However, what we can expect from the court question, the court can ask the question of if the Mr. Bester has found the legal representative, whether the legal representative has managed to consult with Mr. Bester privately the way Mr. Bester wanted to do. With Mr. Bester, it was his concerns that his rights are being infringed. That one, he wanted to wear any attire that he wants. 2, he wanted to consult privately with his legal attorneys.
Sina Komu believes that there are some delaying tactics on the part of Bester.
There is a delayed tactics. There is a delayed tactics on the part of Mr. Bester because if you check the time frame, Mr. Bester has all the times to consult and to speak with the outside person. Remember that when he requests the closing to come to have the closing to go to the court, he's speaking with one of the family or one of a friend or whoever, then that it can be used as a chance for him to consult with the attorney.
Except for Bester and Makgotsa, all other accused have indicated to the court that they are ready to proceed with the trial. Kamogelo Siekwi, SABC News, Bloemfontein.
All right, so Kamogelo covered that particular report for us, and she joins us now live from just outside court in the lead-up to today's proceedings. And Kamogelo, the last time we were there, Tabo Bester, of course, had this dramatic monologue inside the court where he explained that he's having difficulties even consulting with these lawyers because of the associations being made with the case. Today, we're hoping all of that has been ironed out so we can finally have a trial date.
Well, we don't know as yet, Ayanda, if that will actually be ironed out because remember, he did not have a lawyer when he left the court the last time. His lawyers actually withdrew from the case during that court proceeding. So today he's supposed to present a new lawyer to the court who is actually going to then inform the court whether he's been read in terms of receiving the docket and all the other documents that he's supposed to receive so that this matter can proceed. But I do have with me Advocate Ines Bezedin-Holt, who I want to bring into the conversation just for her to help us unpack what is likely to happen inside court today. Remember the last time the lawyer withdrew from the case, and of course today we expect that he will bring a new lawyer. When that happens, when he presents a new lawyer or a new lawyer presents himself to court or herself, what is likely to happen?
Thank you, Kamuelo. In this instance, when there's a new legal representative that appears on record, one expects them or him or her to apply for a postponement in order to familiarize himself with the facts of the case. That is not uncommon. However, one has to look at the history of the postponements already. And one would expect that the lawyer might have already brought himself up to speed with the proceedings. It is a preparatory examination, and remember that this is not the trial. So in other words, there will be opportunity to further see to it that he is more familiar with the facts at a later stage. But one expects a delay in this instance.
Now, let's talk about these delays. This is the third time we are here for a pre-trial, and each time we've been here at the High Court, Bester has had to get a new lawyer. Can't the court do something about it? Is there any recourse or action that the court can take to ensure that this matter actually gets to trial?
One has to remember that your right to legal representation is a right that is enacted in the Constitution in terms of Section 35, as well as in terms of Section 73 of the Criminal Procedure Act. But, however, that right is not an unfettered right. In other words, the court will carefully consider any application to further postpone the matter for legal representation. One can also expect the state or even any of the other co-accused to bring an application in terms of Section 342 Big A of the Criminal Procedure Act to say that this matter has been unreasonably delayed for purposes of obtaining legal representation, and that the court then rules on the matter whether this is unreasonable or not. One can also expect in that ruling that the court will have to look at not only the right of the accused to legal representation, but how that affects the rights of the other accused and also the interests of the state in terms of the proceedings to follow.
Now, let's take it back a little bit to the previous appearance when Bester had that moment where he was addressing the judge. He actually spoke about the fact that his co-accused had nothing to do with this and that he should take the blame. There are two things here. He says he should be blamed for what happened, but on the other hand, he's the one who's actually causing the delays. How do we marry the two?
One has to remember that any statements made in a preparatory examination is not evidence per se. It is, however, evidentiary material that the state can use during the trial. Should, for example, the accused deviate from the statements that he made during the preparatory examination, the state can use that to prove that that was a previous inconsistent statement, and that could ultimately have a bearing on his credibility. So on the one hand, the accused states that he will take all the blame, but on the other hand, one expects them. Why would he then not plead guilty to the charges if he takes the blame? And that could expedite the proceedings. The preparatory examination is truly for purposes of streaming out the issues that might be in dispute in order to expedite the proceedings. One has to remember that we're sitting already with congested court rolls, and to frustrate the proceedings surely is not in the interest of justice.
Could we see the court today saying this should be the last postponement?
That is indeed the case, that the state can apply for that, but then it has to be noted on record that that would be the last postponement for the matter to proceed in terms of Section 342 Big A.
Thank you so much. That was Advocate Ines Bezuidenhout there talking to us about what is likely to happen here, and of course interestingly pointing out the fact that some of the statements that Bester made in the previous appearance when he was here could actually catch up with him at a later stage. With that, it's back to you, Ayanda.
All right, we'll see how everything unfolds. Kamagole Siyekwi, for now, thanks very much indeed. Kamagole is live to us there from just outside the High Court in the Free State. And once again, several steps still need to be taken before we finally get to the crux of the merits of this particular case.